recorded for posterity. It's all yours.
Okay. All right. So I do have an outline that I presided and I presented, and I think they were trying to put it in the chat, and it's probably too large for the chat. I can share my screen if you prefer that, although I don't know. I prefer to actually see people when I'm talking, so I'll probably just talk and ask, and I guess the outline is available. So basically, I'm going to focus on Supreme Court decisions, U.S. Supreme Court decisions, and honestly, there have been fewer, I think, Supreme Court decisions in the last few terms than in previous terms. Like, it always seemed like I was waiting for 3 or 4 different decisions to come down, and now there seem to be fewer. But I want to focus on a few decisions from the last couple of terms, and including some from this current term that haven't been decided yet, but may be relevant, relevant for both employers, unions, and employees, for all of those. So the first case I'm going to focus on is the Helix Energy Solutions Group versus Hewlett case. It's 143 Supreme Court 677, decided in February of 22nd of this year. Basically dealing with wage and hour issues. So Fair Labor Standards Act, right, generally provides for overtime pay, right, for covered employees who work more than 40 hours a week, right? There's an exemption for the bona fide executive employees who are paid on a salary basis if their salary exceeds a certain amount and if they meet a duties test. And then there's, of course, 2 different duties tests depending on whether you're a highly compensated employee, which is more than 100,000 a year, or less than 100,000 a year. So basically, the salary test basically requires employees to receive their full salary for a week, in any week in which they perform work, regardless of the number of days worked, right? There are some exceptions, but that's sort of generally the idea. There is a way for employees who are paid on a basis other than a salary basis to meet the salary test, but it basically involves a guarantee that they still receive that weekly, like they're sort of what they receive each week is a reasonable relationship with what they usually receive. So Hewitt is he's a tool pusher, whatever that means, on an offshore oil rig, supervising 12 to 14 employees. So no question that he would be an bona fide executive employee based on his duties. He works 12 hours a day, worked 7 days a week, so 84 hours a week during a 28-hour period, 28-day period, and then he had a 28-day period off. He's paid daily. That is no overtime compensation. He's simply paid a daily rate. And in the scheme of things, it's a pretty high daily rate. During the period of time, it's between 900 and change a day and 1,300 and change a day. So he's making over 200,000 a year. So I think he's fired. He sues for overtime compensation. And basically the question is whether he's paid on salary basis, right? Makes enough money, he's clearly a highly compensated employee, he meets the duties test. The question is whether he's paid on a salary basis. And the court says, no, right? He's not paid on a salary basis, he's paid daily, right? He gets a daily rate. If he works 3 days, right, in a week, he gets paid for those 3 days. If he doesn't work, if he works more, he gets paid for those days. And so what the court basically says is a salary basis means you're paid on a salary basis, right? Not on a daily basis. The employer makes an argument that he meets the salary basis test because whenever he works at least 1 day, he makes over the minimum that you have to get. I didn't say that. There's a salary, you have to have at least $455 a week, right, to meet the salary. And so the argument is he gets paid biweekly. As long as he's worked one day during that time, he's going to get at least $450 a week, and that meets the salary basis test. Supreme Court says no. Supreme Court basically says, right? So the decision is written by Justice Kagan, joined by basically everybody except Gorsuch, Kavanaugh, and Alito. The majority basically says, right, that this is an attempt, so the employer and the dissent bought the employer's argument. Basically said it was an attempt to power pass the regulatory text and a non sequitur to end all non sequiturs. Court basically says if you're paid on a daily or other rate, you can still meet the test, but only if the employer provides a weekly guarantee that you'll still get basically the equivalent of sort of what your salary would be. Right. So basically, the other argument made was that for highly compensated employees, which he clearly was, that the duties test should be modified, that the salary test should be modified. And the court says, no, the highly compensated test only modifies the duties test. So basically, employer made sort of a policy argument that this wasn't right. People who made this much money weren't intended to get overtime, essentially. And what the court said was, no, right, the policy claim is inconsistent with both the text of the statute and the regulations, and that workers aren't deprived of the benefit of the act simply because they're well paid. Court says employer could come into compliance in one of two ways. It could add to the daily rate a weekly guarantee that satisfies the rules, right? You can keep the daily rate as long as you provide this guarantee that you still basically get what your normal salary would be, what you normally receive during a week, or it could convert the daily rate basically to a straight weekly rate. They could pay them salary. And the employer's objection was, well, then we'd have to pay you for days that you didn't work. And the court says, yeah, that's the way salary works, right? That is, the employer says, right, the court says the employer wishes neither to pay employees a true salary nor to pay them overtime. So I think what's interesting about the case is, again, we think about wage and hour sort of as and overtime requirements, right, as being for the benefit of relatively low paid employees. He's clearly not in that category. He was working 84 hours a week. He was getting no overtime. He sued for several years of a lot of money involved here, lots and lots of money. And the employer was like, this is a windfall to him and something we shouldn't have been expecting. And the court basically says, right, this is what the regulation says. You don't meet the terms of the regulation. The answer is you don't, don't meet the test, and therefore he's entitled to overtime. A couple of interesting, the dissents, I think, particularly interesting, right? Gorsuch would have dismissed the case as improvidently granted because the real concern of the employer was the validity of the regulations. And of course, they didn't raise that issue until too late. The dissent by Kavanaugh and Alito sort of does both of those things. It says, no, under the terms of the statute, even under the terms of the regulation, this, as long as you're paid more than $450 every week, right, which it clearly was if you worked one day, it should meet the statute. But more importantly, they say, right, the regulations may simply be inconsistent with the statute. That is, they say at the end, it is questionable whether the department's regulations would look not only at the employee's duties, but also at how much the employee is paid and how the employee is paid. It's unquestionable whether it will survive when the regulations are challenged and inconsistent with the act. And I think what's interesting, so I 20 some years ago, I did a project for the Department of Labor looking at these rules, right? So this has been a constant issue between different administrations. And what I think the Supreme Court is really doing, or the dissents, whether it ends up being the majority or not, is sort of laying sort of a way to look about whether these regulations are valid at all. That maybe the only issue under the overtime should be what the duties are, not the salary, not how people are paid. And I think that, to me, that's the most interesting part of the case, because otherwise it seems, one could argue fairly that, you know, if the rule is salaried, he was not paid salary. It's not that surprising of a decision that he lost, that he won. I mean, other than truly the amount of money that's, you know, if he was entitled to overtime for 44 hours every week that he worked, right, and he's making up to $1,300 a day, we're talking about a lot of money, right?
Wow.
Should I pause before I go on to another? Okay. Okay, I paused.
You're doing fine. Keep going.
Okay. All right. Okay. So the next two cases, the next issues sort of that I want to talk about are issues with respect to unionization and labor disputes. So the case that the decided case that I want to focus on is the Cedar Point Nursery versus Hesed case, decided actually at the end, this may not fit with the last, it's at the end of, not last term, but the previous term, decided in June of 2021, majority opinion by Roberts, joined by Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, concurring opinion by Kavanaugh, and a dissenting opinion by Breyer, joined by Sotomayor and Kagan. So I suspect you've heard about this case. I just want to talk a little bit about, I think, some of the implications of it. So this is a claim brought by agricultural employers challenging a California regulation granting labor organizations the right of access to property of employers to solicit for unionization. Basically, the regulation allowed access up to 3 hours a day, 120 days a year. So it was, as it turned out, it was an hour before work, hour during the lunch hour, hour after work. And the question was whether it was a takings, right? A violation of the takings clause. And the court holds that, right, the taking clause prohibits governments acquiring private property for public use without compensation, right? Court notes that, right, private property can be subject to regulation, but that if the regulation goes too far, right, it is generally a taking. And that a regulation, the courts held that the regulation requiring union access was a per se physical taking because it appropriated the owner's right to exclude others for the benefit of third parties. What I think is particularly interesting about this case is that the court distinguished its own case in NLRB versus Babcock and Wilcox, decided under the National Labor Relations Act. That case held that essentially, when you were thinking about the access rights of non-employee union organizers, that the rights of the union organizers and the employer needed to be balanced, although basically, unless the employees, the union organizers essentially had very little access to those employees, that was the only way that the employees were going to be, the union organizers going to be allowed on the employer property. So the Babcock and Wilcox case basically was suggesting that most situations, union organizers can have access to employees in other ways, off work, not on employer's premises. Normally you don't get access, but there could be some situations in which the access was so limited. There's always you work at an isolated mining camp, or you work at a resort, which is away from, sort of normal places where you would access the employees. And what the question was, right, the court says, well, that wasn't a takings case, right? We weren't addressing takings there. And so the court says, right, whatever specific taking issues may be presented by the highly contingent access right we recognized under the NLRA, California's access regulation affects a per se physical taking under our precedents. Maybe I'm paranoid, but I've read enough Supreme Court cases that when the Supreme Court says, well, we're not going to address that issue, right, it seems to me that there's at least a number of votes for maybe even the type of access allowed by Babcock and Wilcox might be a takings, right? And so to me, that's the most interesting sort of more general applicability. Otherwise, you're like, it's California. Who cares what's going on in California, right? I mean, I think it has a more perhaps a more generalized issue here. So, right, the real question in that case before the decision came down, I think, was how the court was going to distinguish the government providing union organizers access to property versus all of the other ways in which the government allows access to private property, right? So OSHA investigations and, sort of all of those types of things that were sort of used to happening and not being physical takings. And what the Supreme Court says is, well, your fear that might happen, right, that this decision might affect those types of things, right, is unfounded. What the court said was 3 reasons why, right? First, that isolated physical invasions is the court's term, not mine, would be a trespass, not a taking. So maybe if it happened less frequently, right, it might not be a takings. This is 3 hours a day, 120 days a year. That other types of government authorized physical invasions would be consistent with long-standing background restrictions on property rights. I just don't know what that means ultimately, but sort of maybe other types of takings are sort of more accepted historically. And then I thought, interestingly, that a government can require an owner to give a right of access as condition to receiving benefits without it being considered a taking, which again strikes me as, is this a rule just for unions, right? Is this just a way to provide that unions don't have access, even though other types of access are allowed because there's a benefit? So there's a concurring opinion by Kavanaugh, which basically says this case is entirely consistent with Babcock, or rather Babcock is entirely consistent with this case. I read his concurrence perhaps as suggesting that the court's decision wouldn't affect, right, the validity of Babcock, although I'm not convinced of that. There's a dissenting opinion by Breyer, right, which basically says, right, that this regulation, right, which again allows access 3 hours a day, right, hour before work, hour during the lunch break, hour after work for 4 months a year, was a regulation, not a physical taking, right? It's a dissent, right? But I think what's most interesting is his indication that, right, the employer was getting a benefit for this allowed, right, if they were allowed to have access, union organizers like access, that is labor peace, right? The dissent argues that labor peace brought about through union organizing is a benefit that justifies requiring owners to give a right of access. What I think is interesting about this case is whether it ends up being just a union case. That is an example in which sort of the court's rules are going to be used to apply to unions, but not generally applied sort of more broadly.
I have a question on that, Professor. Babcock dealt with employees who were one of the organized having access to other employees, as I understand it.
No, Babcock dealt with union organized and non-employee union organizers having access.
Okay, and this one dealt with employee, this one dealt with paid union or organizers having access to company property.
Yeah, same circumstances in Babcock and Wilcox. Those were also paid union organizers. Totally different rules if you have employees who are trying to organize. So if employees who are organizing seek access, well, the answer is mostly they get that access because they're employees and they're on their employer's property. Then the rules, it's under Republic Aviation is the standard, but much greater access for employees organizing among themselves than paid union organizers.
Okay, I just wanted to clarify. Thank you.
Professor, if I may ask a question, the last two cases that you've gone through, so you have the Supreme Court in the wage and hour case hinting maybe that we should be looking at duties, not salaries, while the Department of Labor and Congress is looking at increasing that salary threshold. And then in the labor case, you've got the Supreme Court maybe hinting that they're going to restrict union access, while the National Labor Relations Board is doing far more than hinting that they're going to expand union access, which seems to be an interesting push and pull that leaves employers, I don't know, confused. Any advice or any thoughts about this tug of war that seems to be happening in DC?
I mean, I guess I think this tug of war has been going on for a long time. So I suspect it depends on one's perspective and whether one is, I'm trying to figure out the way to say this, whether one is more employer oriented or one is more employee oriented. It doesn't generally take my students very long to figure out what side of that I fall on. And so I suspect I may sound more employee oriented, not accidental. But it does put employers in a really difficult situation, right? So the issues under the wage and hour, right? This has been a long-standing going back and forth, right? So I was involved again in 2000 when I did a study for the Department of Labor when they were trying to decide whether to change the salary test, increase the salary test. It was something really, really low then. It was like even lower than the 400.
Kind of low.
Right, yeah. And then, right, new administration came in and there's been different versions of these regulations. They've never dropped the salary part, right? It's always been a question of what that salary is going to be, right? But it seems the Supreme Court is suggesting maybe those regulations are unlawful altogether, right? Which are invalid altogether, which would suggest that maybe it would only ultimately be about, right, the duties and have nothing to do with what people are paid, which would be such a huge change from the regulations, what's been in effect for the last lots of years, right? So no, I guess I don't have much advice except to know that I suspect whenever you're dealing with agencies whose composition changes fairly dramatically over administrations, planning must be particularly difficult. The National Labor Relations Board does that, I think, more than any other of the entities that you're probably dealing with, right? I teach employment discrimination as well as labor law, and the EEOC changes its composition, but doesn't. There's some change with respect to regulations, but when the board does it, board changes over, it is much more dramatic. Not very helpful, I suspect.
No, I mean, you've justified my paranoia and confusion, so I appreciate the validation.
Okay. So the second union-ish case, well, it is a union case that I want to mention is one that is the court is considering, right? The question is not, the case has not yet been decided. This is the Glacier Northwest versus International Brotherhood of Teamsters Local Union 174. Cert was granted in October of last year. Question presented is, does the National Labor Relations Act impliedly preempt a state tort action against a union for intentionally destroying an employer's property in the course of a labor dispute? That's the way the question was phrased. And granted cert on. So lower court decision is from the Supreme Court of Washington, held that an employer's state tort action claim against a truck drivers union was preempted by the National Labor Relations Act. Employer essentially suing over loss of a concrete product that occurred during the strike. That is, concrete had already been loaded into the trucks that move around and keep the concrete from setting, right? And there was a strike, work stoppage, right? Employer claimed that the strike was timed to cause destruction to the concrete and that the drivers knew that the concrete was perishable. And the claim was for, right, the loss of damages to the concrete and also the fact that the concrete couldn't be delivered because the drivers were on a work stoppage, and therefore the projects, right, that it was supposed to be used on. I learned more than I knew about concrete generally from reading this decision, right? Apparently also, if a concrete stays in the trucks, it like freezes up and destroys the trucks, but actually that part didn't happen. They did unload the trucks, and so the trucks were not damaged. So lower court held that the state court claims preempted under Garmin preemption, basically because the conduct of the truck drivers was in connection with a strike, arguably protected under Section 7 of the National Labor Relations Act, right? Concerted action for mutual aid and protection. Strikes are protected activity, work stoppages protected activity. Lower court thought that it wasn't within the exception to preemption, essentially because the truck driver's conduct wasn't intentional destruction of property for its own sake, but incidental destruction to the property during a strike, right? So fairly broad, generally, state preemption of state claims with respect to the National Labor Relations Act. So the question is, what is the court going to do? My view is the Supreme Court is likely to use this case to limit the scope of preemption under the National Labor Relations Act. I know it's always probably not a good idea to try to guess what the court's going to do based on the fact that it grants cert, but it seems to me unlikely that the court took this case simply to affirm the existing parameters of Garmin preemption, right? So it strikes me as that the standards of preemption are very likely to change, or at least, right? That's what, if I were an employer, right? I would be thinking about, watching that case with respect to what's likely to happen there. That's my pause. Okay. So the next set of cases that I want to talk about are both, I have them under the category of employment discrimination. They're really religious discrimination cases or religious issues. Yeah, let me talk about them. So the first case is Kennedy versus Bremerton School District, decided at the end of last term. this is a decision written by Gorsuch, joined by Roberts, Thomas, Alito, Barrett, and Kavanaugh, concurring opinion by Thomas and Alito, and dissenting opinion by Sotomayor, Breyer, and Kagan. So this case involved Kennedy, right, a high school football coach. He sues under 42 USC 1983 after losing his job for what the majority called a quiet prayer of thanks at midfield after games. Basically, there's a pretty extensive description of the facts of the case, right? That he started praying by himself at right after the games. That other players asked if they could pray with them, and that the group grew over time to include most of the team, but that there was no coercion involved, that it was, a private prayer that sort of grew, but voluntarily. The dissent says that the majority mischaracterizes this because basically he had consistently held prayers at the 50-yard line after games, that he had consistently invited others to join them. And what I thought was most interesting is the dissent provided pictures, right, of these groups, which did not look like quiet, solitary prayer, right? It's big groups of people. And the court granted summary judgment for the plaintiff, and I'm always particularly fascinated by cases in which summary judgment is granted for the person who would have the burden of proof at trial, right? It just always interesting, and in a context in which at least the majority of the dissent thinks there are a lot of factual issues. So what's the court hold? The court holds that the free exercise clause and the free speech clause of the First Amendment protect an individual engaging in personal religious observance from government reprisal, and that the Constitution neither mandates nor permits the government to suppress such religious expression. The court very much sees this as, right, he is trying to exercise his personal rights to engage in religious behavior, and that the school board's decision is not a neutral decision. It is disfavoring religion. Right, and in light of that, the court says the school board has an obligation to satisfy strict scrutiny, such that the restriction, right, has to serve a compelling governmental interest and be narrowly tailored. And basically, the argument was that the school district had to take this action to avoid establishment clause problems, and the court basically says no, right? The court says a rule that the only acceptable government role model for students are those who eschew any visible religious expression would undermine a long constitutional tradition in which learning how to tolerate diverse expressive activities has always been part of learning how to live in a pluralistic society. So the court treats this very much as that he is being disfavored. His expression of religion is being disfavored as opposed to other secular activities. The court talks about how when other people were like using their cell phones to call home and things like that, he was praying. What I think is interesting is the other opinions, right, in the case, right? So the concurring opinion by Thomas basically says that the court doesn't resolve, because he's acting privately, right? This is private action. The court doesn't resolve whether employees' free exercise rights are different from those of the general public, and what burden a governmental employer must bear to justify restricting employees' religious expression. A concurring opinion by Alito indicates that the court doesn't decide what standard applies to private expression by employees under the free speech clause. So I think that the majority and the concurring opinions are sort of trying to separate this out from the employment aspects, right? This is private action. This isn't an action as an employee, right? There's some discussion about his speech is not government speech, the Garcetti case, right? He's speaking as a citizen, not as an employee. Dissenting opinion, right? Sotomayor basically indicates, right, that the majority's entire focus is on free exercise, not on the Establishment Clause, right? Says properly understood, right? This was, he was basically leading prayers of his students, right? This should be an Establishment Clause issue. The sentence says, court elevates one individual's interest in personal religious exercise at the exact time and place of that individual's choosing over society's interest in protecting the separation between church and state, eroding the protections of religious liberty for all. So I think what's interesting about the case is sort of the court's, and I think the court has been shifting on the issue of religious liberty, sort of more in favor of religious liberty, which is not necessarily a bad thing, right? But I think sort of it's a little hard to figure out how this case is going to apply outside of this context. But I do think that there may be more protection for employees engaging in religious activities in the context of the workplace, right? I mean, this was after the game, but it was still in the context of his workplace. Sorry, my computer's doing strange things. Okay. Okay. So that's one of the two religious liberty cases, the religious discrimination cases. The other case is the Groff versus DeJoy case. It was docketed in August of 2022. Question presented, and here I think there's, it's always bad to predict why courts take cases, but here it seems to me, given the question presented, I have a pretty good sense of why the court took the case. So the question presented is whether this court should disapprove the more than de minimis cost test for refusing Title VII religious accommodation stated in Trans World Airlines versus Hardison, right? So, right, generally the answer is religious discrimination claims, religious accommodation claims under Title VII have been very, very hard for plaintiffs to win, right? Because the standard is, yes, you have to accommodate, but not if there would be an undue hardship. Undue hardship is anything more than a de minimis cost, right? This is from the Supreme Court's own cases. The second question that they granted cert on was whether undue hardship on the conduct of the employer's business under Title VII, whether an employee may demonstrate undue hardship on the conduct of the employer's business under Title VII merely by showing that the requested accommodation burdened the employee's co-workers rather than the business itself. So this is the lower court decision is a Third Circuit decision. Plaintiff brings a Title VII case against the U.S. Post Office for failure to reasonable accommodation of religion because he asked not to have to work on Sundays because of his religious beliefs. There was once upon a time in which the post office didn't deliver on Sundays, but once it entered contracts with Amazon, it started to deliver on Sundays, and so. He basically, the accommodation he was offered is that the post office would try to find employees to swap shifts with him, but sometimes it wouldn't happen. That is, they couldn't find employees. When he didn't work on a Sunday, he was disciplined and he ultimately left the post office. So Court of Appeals found that the employer's offer to find someone to swap shifts was not a reasonable accommodation because it didn't actually avoid the conflict, right? But that accommodation of exempting him from Sunday work would have been an undue hardship on the employer. Again, following the Supreme Court's decision in Hardison, anything more than more than a de minimis cost would be an undue hardship. And basically, in finding an undue hardship, the lower court considered the impact of the accommodation on the plaintiff's co-workers, including the fact that they would have to give up time with their families to cover the Sunday shifts that the plaintiff didn't work. Here, I don't think, right, I think I'm fairly safe in predicting, although I've been wrong before, that the Supreme Court will use this case to overrule Hardison, right? That is, there has been an indication from some members of the court that they were unhappy with this test. I actually have been unhappy with this test for a long time when I teach employment discrimination, but I think it's very likely, right, that the court did not grant cert in order to affirm a 46-year-old precedent, right? The court granted cert, I suspect, to overrule this precedent. I would note that the Supreme Court has overruled a number of pretty old precedents in recent years. So I do think that the hard questions are going to be what test is going to replace it, right? I don't think that the test will be de minimis. I don't know what the court is going to use to replace it, but I think this is an area of religious accommodation that there's likely to be a significant change in the current rules. That was my pause. Okay. The next issue I want to talk about is employee benefits. I'm always a little nervous about this because I never know if employee benefits fits within labor and employment law. But I'm going to talk about it anyway. I teach an employee benefits course, so I now think that it fits within employment law. So if you don't, bear with me. So basically, ERISA, right, the Employee Retirement Income Security Act imposes a fiduciary duty on plan administrators, including the duty of prudence. Duty of prudence generally includes the duty to monitor all plan investments and remove any plan investments that are imprudent. I'm sorry, I should have said, this is the Hughes versus Northwestern University case decided in January of 2022. Majority opinion by Sotomayor, but everyone joined it other than Barrett, who didn't participate. So petitioners were current and former employees of Northwestern University who participated in defined contribution plans sponsored by the employer, right? These are 401ks. Participants in the plan maintain individual investment accounts funded by salary deferrals and matching employer contributions, which each participant choosing how to invest their own funds from a menu of options selected by plan administrators. So basically, a lot of recent challenges to fiduciary duties and for context of 401ks have dealt with fees, excessive fees. And this was the claim here. The claim was that the fees that were charged both for investment management services and record keeping services, keeping track of the accounts, were excessive. So the claim breach of fiduciary duty were that the fees charged were excessive, and it was because of the failure to monitor the fees charged. That the plan offered a number of choices with higher fees when there were identical investments with lower fees, and that the plan offered, I thought this was particularly interesting, too many investment options. There were like 400, causing participant confusion and poor investment decisions. That is, we had too many choices, sort of in this sense. Lower courts dismissed the claim of breach of fiduciary duty, basically saying, because the plan offered a diverse range of options, including investments with lower fees, it precluded a claim for breach of the duty because essentially the participants chose those investments with higher fees when they could have chosen investments with lower fees. And the Supreme Court says no. The Supreme Court says even in defined contribution plans where participants choose their own investments, plan fiduciaries are required to conduct their own independent evaluations to determine whether investments may prudently be included in the plan's menu of options, and that failure to remove an imprudent investment option constitutes a breach of the duty of prudence. So what I think is important, right, if the case had gone the other way, essentially it would have been very difficult to make breach of fiduciary duty claims, duty of prudence claims in this context, right? Because as long as you had enough options, right, in which there were both options for lower and higher fees, there could be no claim of breach of fiduciary duty. The court remands the case to the Court of Appeals basically to determine whether the petitioners had plausibly alleged a violation of the duty of prudence. the court does say that the circumstances facing a fiduciary, a risk of fiduciary, will implicate difficult trade-offs. Courts must give due regard to the range of reasonable judgments a fiduciary may make based on her experience and expertise. So again, I don't know how many of you deal with ERISA on a regular basis, but I think it's been difficult to make some of these duty of prudence arguments. So I think this court makes it somewhat easier sort of in that context, at least sort of the range of options, right, doesn't relieve the fiduciary, the plan administrator. Plan administrators are often the employer, right, from, you know, sort of offering this for the options. They still have to have the duty regardless of the options that they present. Two last cases that are not employment law cases, but I want to at least mention that I think have some implications for employment law. The first is the Maori versus Norfolk Southern Railway Company case, granted cert in April of 2022. The question is whether the due process clause of the 14th Amendment prohibits a state from requiring a corporation to consent to personal jurisdiction to do business in the state. Those you are thinking like, oh, personal jurisdiction, I don't have to think about personal jurisdiction again, right? But Fornoria versus Knapp and all that stuff, right? The reason I think it's relevant, right, with respect to sort of employment, right, is because the Pennsylvania Supreme Court, right, the question was, an employee had filed suit in Pennsylvania against their employer for injuries that occurred in other states. It was basically exposure to toxic chemicals, right, had occurred in Virginia and other places. Pennsylvania statute provides for general personal jurisdiction over a corporation based on a foreign corporation's registration to do business in Pennsylvania. Pennsylvania Supreme Court says, right, that statutory scheme violates due process absent contacts with the state that are continuous and systematic, and that requiring consent to general personal jurisdiction as a condition of doing business in the state is not constitutionally permitted. Again, I worry about becoming the, you know, like the law professor, right, to try to tell you the difference between general and specific jurisdiction, right, which again, you probably tried not to think about recently, right, but right, if the court were to overrule the Pennsylvania Supreme Court, right, what it would mean essentially is, right, employees could bring employment-related cases, right, against their employers in any state in which the employer is registered to do business, at least any state that has a similar type rule, right? So I think, I don't know what the court's going to do. I don't even, I'm going to get a registered guess about what the court's going to do in this situation, right? That there's a split in the circuits, and so the fact that they grant the cert doesn't mean the court's going to do any particular thing, but that's sort of the, I think it's at least worth watching. The other case, right, that is clearly worth watching, even though it's not an employment case, is the Students for Fair Admissions versus President and Fellows of Harvard College, and also the North Carolina. So question presented here, of course, is whether the court should overrule Bruder versus Bollinger, of holding that institutions of higher education can't use, so that it could say that it couldn't use race and factor as admissions. Right. Also, the question about the equivalent question of Title VI of the Civil Rights Act, which bans race-based admissions, that if done by a public university would violate the Equal Protection Clause. Right. So it applies with private and public employers. I think it is extremely likely that the Supreme Court, with a 6-3 conservative majority, will finally rule that the use of race in education is unconstitutional. I think the question is how far that case extends to the employment context, right? This Supreme Court could certainly say that use of race in any context is unconstitutional, and may do so. But I think really the question is going to be the effect on the validity of diversity initiatives, affirmative action for federal contractors. Certainly industry groups and companies thought this was likely to affect them because there are a lot of amicus briefs asking the court to uphold the use of race for diversity admissions. now I will really pause, because those are the cases that I that I wanted to bring to your attention. So I'm happy to answer questions on any of the cases if there are questions.
Any comments from anybody? Well, Professor, I could have lived the rest of this week without hearing about in personam jurisdiction. My head hurts already.
Yeah, most of my students, I don't teach civil procedure anymore, but that's certainly the way they felt about it at the time.
No, I appreciated your comments. Just when we thought all we'd be talking about from the NLRB is college athletes, but you gave us some other cases we should probably keep our eye on. So that was pretty cool. I appreciated that. Anybody have anything else? All right, well, thank you for your comments, and I do appreciate and look forward to your presentation on the 23rd of June. For those of you that don't know, 23rd of June is the OSBA's public practice seminar, which Professor Hébert is one of the speakers. So put that on your calendar, if you will. But for the rest of the group, I want to remind you that our next meeting and final meeting of the year is on May 16th. It's going to be held at OCSEA headquarters. It is an in-person presentation, and look forward to the announcement. Pay attention and look forward to the announcements with that. So with that, I'm going to turn this over, about to turn this off, really. But thank you again, Professor, for your presentation. That was pretty good. Again, I liked it. So any comments from anybody? Have you all sent in your CLE numbers in your chat box? Yeah, I assume you have. So, well, good. Thank you very much. With that, unless there's nothing else, everyone, I'm gonna, cut this off, and we'll see you all later. All right, thank you. All right, bye-bye.